reform. So a lot of the issues that I'll talk about are connected to work that I've done with Paula and with LGBT Ireland, where we've identified some remaining issues affecting LGBT plus families and come up with proposals for law reform that is needed to address them. I think it is a very important topic to talk about under the theme of justice and safety, because although there was a very recent development yesterday, as it currently stands, LGBT plus families cannot obtain full legal recognition of their family relationships in 2019. Okay, so there's a lot of work that needs to be done. You know, progress has been made, but much more needs to be done as well. So I'll highlight some of those issues in my paper. So some of the main issues that arise in this area relate to the Children and Family Relations Act 2015. So I'm sure a lot of people are familiar with that piece of legislation, and I'll refer to that as the Cf4 Act. So this was a piece of legislation that was introduced just a few months before the marriage equality referendum in 2015, and the timing of the legislation was, I suppose, designed to ensure that parenting issues and debates didn't then kind of creep into the marriage equality debates. That didn't happen overly successfully, but you know, at least it meant that the parenting issues had been dealt with by the time that the marriage equality referendum came along. So the Cf4 Act regulates what's known as donor-assisted human reproduction, or DAHR. So that is basically assisted human reproduction that uses a donor gamete, so donor eggs or donor sperm, or it uses a donor embryo. Okay, and it sets out that where a couple, whether that's a female couple or an opposite sex couple, engages in DAHR, the woman who gives birth to the child is regarded as the legal mother, and then her partner, again whether it's her male or female partner, is the second legal parent. A major issue is that parts 2 and 3 of the Act that relate to DAHR have not yet been commenced. Okay, so that means that they are law, but they don't actually have force of law yet, so they have no practical application. So if a female couple engages in DAHR, it remains the case that yes, the woman who gives birth is regarded as the legal mother, but her partner still has no opportunity to be recognised as a legal parent, and she can't be recognised until all parts of the Cf4 Act are commenced. So we might think, well, why has there been this 4-year, nearly 4.5-year delay in terms of commencing the legislation? The first issue that arose was that there was a typographical error in the Cf4 Act. So there was a typo in relation to one of the definitions of who a donor is. Okay, that has now been fixed. You might remember last summer there was a lot of media outlets reporting on the fact that same-sex couples can now register the birth of their children, because the Children and Family Relationships Amendment Act was brought in and it fixed the typo, so we kind of thought, well, everything has been sorted now. Unfortunately, further errors were then identified. Okay, so these have been identified and they've now been caught by the Civil Registration Bill 2019, and that actually just passed through both houses of the Oireachtas yesterday, and it's now going to be presented to the President. Okay, so the errors have been fixed, and there is, I suppose, a commencement date coming down the line for the Cf4 Act. Before it can be fully commenced, we do need, I suppose, other steps to be taken. So there needs to be administrative and operational arrangements put in place. That includes things like the establishment of a national donor conceived person register. So for every child who will be born from DAHR, their details will be recorded, and also the details of their donor will be recorded, so they can have access to that information in the future. So Paula probably can speak to this a bit more. I don't think we have an absolute date for commencement, but it seems like it might happen before the summer, which will be obviously a great relief to families who've now been waiting for 4 years for the Act to be commenced. So that's one issue. There are, however, a number of other issues that arise in relation to parenting. So even after the Cf4 Act is fully commenced, and hopefully that will happen before the summer, you know, a lot of families won't be captured by its provisions, okay, and it doesn't cover every situation. So these are the areas that I've been working with LGBT Ireland on. We produced a briefing document called Pathways to Parenting, and it explains all of these issues in further detail, and it explains, I suppose, the legal steps that we think need to be taken in order to address these issues. Okay, so I'll just briefly outline the 5 main issues now, and then I'll go through each of them in a little bit more detail. I've included case studies from the briefing document, which are based on real people, and it shows, I suppose, it helps to highlight why those areas need to be amended and need to be addressed. So the first area relates to non-clinical DAHR. So when I talk about non-clinical DAHR, basically I mean any DAHR procedure that doesn't take place in a fertility clinic. So for example, a person might choose to undertake a procedure in their own home, and and they might do that for reasons of privacy or for reasons of cost, because it's obviously going to be a lot cheaper to do it in your own home. If you choose to do that though, you would not be covered by the Cf4 Act, okay? So the rules that I talked about in terms of your partner being able to be recognised as a legal parent would not apply. In my view, I suppose coming at it from a children's rights perspective, I think this is very problematic because it means essentially that children who are conceived in pretty much identical circumstances, so one in a clinic and one not in a clinic, are going to be treated very differently under the law. Okay, they're going to have different family relationships because of something that was obviously completely outside of their control. So I think that we do need, legal intervention to recognise aspects of non-clinical DAHR. The second point relates to retrospective declarations of parentage. So a very positive aspect of the Cf4 Act is that it does recognise that, firstly, it took a very long time for it to be enacted, and then now obviously it's taken a very long time for it to be commenced. So there's a provision in the legislation that allows for couples or individuals who already have children through DAHR to retrospectively apply to be recognised. So basically, if you and your partner already have a child through DAHR, currently your partner is not recognised as a legal parent, after the act is fully commenced, you'll be able to go to court so that both of you can be recognised. That, however, is not possible if you've used a known donor. Okay, so if you know the identity of your sperm donor or your egg donor, you won't be able to be recognised as a legal parent. Okay, again, that is problematic because this is one of the central themes of the Cf4 Act is around the child's right to identity and ensuring that children can have access to information about their donors. So if you had a couple who chose to use a known donor for that very reason, so they wanted their child to know who the donor is and have access to information about them, they're now being penalised because the second parent can't be recognised. Okay, so it creates a lot of problems in that way. The third point relates to reciprocal IVF. So for female couples, that would be a situation where one of the partners has provided her egg, that's been combined with donor sperm, and then the embryo has been carried by the other partner. Okay, so it allows all of the women to be physically involved in the pregnancy. But it's not currently included in the Cf4 Act. Well, I should say it's not currently included, but it's not expressly excluded either. Okay, so there is a question mark just about, well, whether the Act applies and if so, how. Okay, in particular, if you're going to be classified as a donor, in which case you have no parental rights, or in which case you are a legal parent with full parental rights. The fourth point is in relation to after commencement, children who are born outside of the state through DAHR. So after commencement, the legislation will only apply to procedures that take place in Ireland. Again, I suppose there's issues there because there are some procedures that simply aren't available in Ireland. Okay, so people will have to travel abroad to engage in them, and then when they come back, their family relationships might not be recognised. And the final point to note is that the Cf4 Act does not address surrogacy. Okay, so for male couples, they are not going to be covered at all by the Cf4 Act. Instead, surrogacy is proposed to be regulated in the Assisted Human Reproduction Bill 2017. Excuse me. And Paula and I gave evidence to the Oireachtas Committee on Health on the Assisted Human Reproduction Bill. I think we, along with a lot of the other witnesses, were very critical of the bill as it currently stands because it's a very restrictive model of surrogacy that's proposed. And we don't feel that it would adequately reflect the reality of surrogacy in Ireland in 2019, and so a number of changes I think are needed. So to explain, I suppose, each of those issues in further detail, in our briefing document we have used a number of case studies that I think help to highlight a lot of the practical difficulties involved in the fact that a lot of these areas have been excluded from the legislation. So the first point I mentioned was in relation to non-clinical DAHR, so if you're engaging in a procedure outside of a clinic, the difficulties that arise there. And we see this in our case study concerning Elaine and Jenny. So Elaine, who is the birth mother, and Jenny conceived their baby girl at home using sperm donated by Jenny's brother. They had no problem conceiving and did not need any clinical intervention. Their donor is happy to give consent to both women being recognised as legal parents. As this is a non-clinical procedure, Jenny is not recognised as a legal parent. In addition, as their baby is only 3 months old, Jenny is unable to seek guardianship under the Cf4 Act because the child is less than 2. So I should say as well, so guardianship is a mechanism that is available to give you some, I suppose, rights and responsibilities in respect of a child, But for someone acting in the capacity of a step-parent, there is a 2-year waiting period before you become eligible to apply. So that's why in this situation, Jenny would have to wait until their child is 2. So without getting into the legal detail of what we proposed in terms of addressing this, we have, I suppose, suggested that we do need some mechanism to allow the second parent to be recognised in cases of DAH or where certain conditions are met. Okay, so it couldn't be, I suppose, a blanket way of recognising people, but there needs to be, I suppose, some acknowledgement of it, given that it's going to happen and children are going to be affected by it. The second point was in relation to the retrospective declaration of parentage and how it's not possible if you've used a known donor. So the difficulties here can be seen in our case study concerning Jane, who's the birth mother, and Sarah, and they have an 18-month-old baby boy, Jake. Jake was conceived in a fertility clinic using sperm provided by an identifiable donor. Jane and Sarah want Jake to know about his origins, and so they have obtained identifying information about the donor so that they can educate Jake about his genetic background in an age-appropriate manner as he grows up. After parts 2 and 3 of the Cf4 Act are commenced, Sarah will be unable to obtain a declaration of parentage, listing her as a second parent because a known donor was used. Okay, so we've argued that that is, I think, too restrictive because, when people were planning their families, they didn't know what the legislation was going to say. And so we need to remove the requirement that the donor has to have been unknown and that there will be a separate procedure for where a known donor has been used that would allow you to apply to court. The third point relates to reciprocal IVF, so where one of the partners provides her egg and then the embryo is carried by the other partner. And it's not clear how the legislation applies here. Okay, so in this case study, we have Renee and Audrey, and they have a 2-year-old daughter, Ava, and are expecting their second child. They might even have their child by this point. Both children were conceived using Audrey's eggs and donor sperm. As the birth mother, Renee is the legal mother of Ava. Audrey will be unable to apply for a declaration of parentage, as potentially she's classified as a known donor under the Act. When their new baby is born, again, she'll be unable to establish guardianship for at least 2 years. Okay, so I think to fix this, it is quite a simple fix. But we just need to clarify that where someone provides an egg for their own reproductive use, that they should be classified as a parent and not as a donor, in which case they don't have any parental rights. Okay, the fourth point, and I hope I'm not going too quickly through all of the scenarios, but the fourth point relates to children who will be conceived after the legislation is commenced. Okay, and for that, the procedure has to take place in Ireland. You might think, well, maybe that's fair enough. Why would Irish legislation try to regulate something that's happening outside of Ireland? But again, as our case study shows, it's not always that black and white, and there are situations that would require that kind of flexibility in the law. So in our case study, we have Sue, who's the birth mother, and Teresa, and they have a daughter who was born following a DAH procedure conducted in a UK clinic. The clinic is storing embryos for the couple's future use. When parts 2 and 3 of the Cf4 Act are commenced, Teresa can apply for a retrospective declaration of parentage. However, if the couple have another child through DAH in the UK clinic, using the stored embryos, the procedure will not be recognised under the Cf4 Act. And it's also unclear whether the Act would apply if they decided to transfer their embryos to an Irish clinic, with all of the costs that would go with that, and obviously it would mean that they're leaving a medical team with whom they've already had a very positive experience. Okay, so to address this, we've kind of come up with 2 proposals. So the first proposal is that, in a sense, there should be a period of amnesty in which anyone who is currently storing gametes or embryos abroad, already has a child and now wants to have a genetic sibling for their existing child, should have a period of time in which they can use those embryos and then have that relationship recognised. And then going forward, it would be sensible and prudent for the state to consider entering into a bilateral agreement with countries that offer DAH to Irish couples. As I said, there are a lot of procedures that are simply not offered in Ireland, so people might have to travel abroad if they're to have a child, and so that just creates difficulties when they're coming back to the country with their child if it's not otherwise recognised. Okay, so a bilateral agreement would resolve a lot of those points. Okay, and then the final point relates to surrogacy. So I think I could have done the whole presentation just on surrogacy alone, so I'm definitely not going to do justice to how complicated the area is. But I suppose the main point to note is that surrogacy is not regulated in the Cf4 Act. Instead, it's proposed to be regulated in the Assisted Human Reproduction Bill, or the AHR Bill. It's a very restrictive model of surrogacy that's proposed. There's a number of difficulties that I see with it, but for now we'll just focus on 3 main points. So the first point is in relation to parentage itself, so how you are determined to be a parent. The second is in relation to international surrogacy, the fact that it's not currently recognised at all in the legislation, so it would just apply to Irish procedures. And then the final point is children who've already been born. Okay, so children born before the Act come into force, currently again not recognised. So to talk about the parentage aspect, the bill currently proposes quite an onerous 2-step process for how a surrogacy arrangement would work. So the first step is that you would need to have your surrogacy agreement authorised by a new body referred to as the Assisted Human Reproduction Regulatory Authority. Okay, so that would essentially be permission to engage in the surrogacy. It would not affect the legal status of who the parents are in any way. So then when you have your permission, the legal or the medical procedure can take place, and then hopefully a child will be born. When the child is born, the surrogate is recognised as the legal mother. Okay, one of the intending parents, if say one of the male partners has contributed their sperm, they could be recognised as the legal father, but then the other intending parent is not going to be recognised as a parent at all. There is a provision then that would allow for parentage to be transferred from the surrogate to the 2 intending parents. Okay, and this is by way of a parental order, which is a little bit like an adoption order in that it's a complete transfer of parentage from one party to the other. A difficulty, though, is that you can't apply for your parental order earlier than 6 weeks and not more than 6 months after the child's birth. Okay, so that means for the first 6 weeks of the child's life, at least one of the intending parents is not recognised as a legal parent. They don't have any rights and responsibilities towards the child. So rather than this post-birth model of parentage, we have argued that a preconception approach would better balance the rights and interests of everyone involved. In a preconception approach, you would go to court before the surrogacy ever takes place. The court would authorise your surrogacy first of all, and then secondly it would determine who the parents are at that point. So before the child has ever been conceived, you know exactly who the parents are. And then when the child is born, the surrogate is not recognised as a legal parent. So instead, both intending parents are recognised from the moment that the child is born. There's no need for them to go back to court after the child is born when they're obviously very busy caring for a newborn. So in that way, I think that would be a preferable approach, and one that, again, as I said, kind of balances everyone's rights a bit better than the approach that has been proposed. The 2 final issues then are firstly in relation to international surrogacy. So the bill proposes that it would just regulate Irish procedures, so procedure conducted in Ireland with an Irish surrogate. International experience shows us that regardless of what our domestic laws say, people are still going to travel abroad for surrogacy. So this is, I think, is really a head in the sand kind of approach that's ignoring the reality of what's going on. So to address that, we've argued that we should have provisions in the bill that would allow for international surrogacy to be recognised, where children have been born abroad and then they're seeking to come back to Ireland. And then the final point is in relation to children who've already been born. So another point to note is that Ireland is currently the 2nd highest user of surrogacy per capita in the world. Okay, so we rank just behind Israel on that. So a lot of children have already been born through surrogacy. But yet, the AHR bill makes no provision to recognise those children. Okay, so by contrast, when I talked about DAHR and children who've already been born, there is a provision in the Cf4 Act to allow for a retrospective declaration of parentage, but that's not included in surrogacy. So we've argued that a similar provision to allow for a retrospective declaration of parentage should be included in any regulation of surrogacy. Okay, so those are the main issues that Paula and I wrote about in our briefing document. Just to briefly plug my own work, I'm currently working on my monograph, which is Same-Sex Parenting and the Best Interest Principle, which discusses a lot of other issues relating to LGBT plus parents. And so I'm very happy to answer any questions during our Q&A session later, and thank you very much for your time.